If we have assets in another state, how will that impact our financial planning for long-term care in Florida? Attorney Kellen Bryant explains. Under Florida law, if you're a resident, your personal property is considered a Florida asset. For instance, if you set up a bank account at a small local bank in Iowa and you move to Florida, that Iowa bank account is actually considered Florida personal property. Now, if you own a condominium in Iowa, that's real estate, and it's considered an Iowa asset. Long-term care planning in Florida, as it relates to out-of-state real estate, is not a complicated distinction. Florida long-term care planning laws will treat out-of-state property the same as it would in-state property. For example, income-producing real estate in Florida is a non-countable asset for long-term medical care planning. If you have a rental property in another state, as long as it's considered rental property, it is exempt even though it's not in Florida. The Florida Medicaid rules do not make a distinction for income-producing property. The distinctions with respect to out-of-state real estate are in the primary residence. For instance, somebody who lives in South Georgia and gets their care in the northern Florida panhandle will have protections extended to their home. In that case, the home will be protected in Florida. However, the ownership of that primary residence at death will be subject to the state laws where the property is located. If you have out-of-state real estate, that's where you want to consider an irrevocable living trust because you may have to do probate in Florida and in the state where the real estate is located. You will have to clear title to be able to handle that asset. If you have out-of-state real estate as a Florida resident, it's very important to consider a revocable living trust for estate and long-term care planning. Put your mind at ease and make an appointment to meet with the Berg Bryant Elder Law Group in Jacksonville, Florida today.